Judiciary Committee is called to order, and we will open the hearing on House Bill 2517, transferring the responsibility to certified drug abuse treatment providers that participate in the Certified Drug Abuse Treatment Program from the Department of Corrections to the Kansas Sentencing Commission. And we will ask for a bill brief from the reviser, Mr. Thompson.
All right, so thank you, Madam Chair. House Bill 2517 was requested in the House Committee by Scott Schultz with the Kansas Sentencing Commission. He's here to testify. I see him right behind me here. It went through the House Committee on Corrections and Juvenile Justice, and it passed the House 120-0. The bill is just a couple of sections, fairly straightforward. It transfers the responsibility of certifying the drug abuse treatment providers that participate in the Certified Drug Abuse Treatment Program. That's what you guys usually call the Senate Bill 123 program. So that should give you some context. And it transfers those responsibilities from the Department of Corrections to the Kansas Sentencing Commission. Section 1 there is KSA 21-6824. That's our statute on the Certified Drug Abuse Treatment Program, created years ago as part of Senate Bill 123, and that's where that name kind of lingers from. Subsection G is amended just to change the definition of mental health professional to reference the Sentencing Commission as the certifying entity as opposed to the Department of Corrections. Section 2 was added to the bill by the House Committee on Corrections and Juvenile Justice. It was just an oversight in the drafting. You may recall in 2021, the legislature enacted KSA 21-6825 as part of a bill that created a certified drug abuse treatment program for folks who go on diversion. So this was that new statute you created last year, and in the drafting process, we just missed that there was this new one that also had the same definition of mental health professional that would also need to reference the Sentencing Commission and not the Department of Corrections. So we corrected that issue in the House Committee, and that's why Section 2 is on a little different bold font, because it was added in House Committee rather than in the drafting. And finally, then Section 3 is really the main piece of the bill, amending KSA 75-52, it changes the references from the Secretary of Corrections to the Kansas Sentencing Commission. And then subsection B is amended to provide that the commission may establish a process for revoking certification of programs that do not meet the commission's qualifications for certification. So this gives all the authority from the department to the Sentencing Commission, and also gives them authority to establish a process for revoking certification, which is maybe not as clear in the statute as it should be, and this would clarify that issue. So be happy to answer any questions and stand aside for the experts to testify.
Committee, questions for the reviser? Thank you, Mr. Thompson. Appreciate that. And with that, then, we will invite our proponent conferee, Scott Schultz, Executive Director, Kansas Sentencing Commission. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Scott Schultz, Executive Director with the Sentencing Commission. Appreciate the opportunity, and thank you, the Chair, for hearing this bill today. This is it did not get in the bill. But the language, it should be called the Sentencing Commission Once More Work Act. But I think that's what it was called on the House side. But this is essentially what Jason has explained. This is kind of an administrative change that is required. A statutory amendment is actually required. And so we have vetted this with Secretary Zamuda. He is also a member of the Sentencing Commission as well. He has no objection to essentially transferring a position that certifies the treatment providers that are all in your districts that provide this treatment for offenders that are court ordered into this program. So this would essentially just bring that particular position under the auspices of the Sentencing Commission. So it is I have already been in discussions with Ways and Means as well as House Appropriations as far as the fiscal impact of this, which essentially is nothing, because we're just transferring from DOC to Sentencing Commission. But that is actually going to probably, depending on the circumstances here, be brought up in an omnibus. So with that, that's all I have. I appreciate your attention and would stand for questions.
Thank you, Mr. Schultz. Are there any other proponent conferees in the committee meeting room or online? Seeing none, then any questions for our proponent conferee from the committee? Seeing none, then thank you very much, Mr. Schultz, for appearing today and for your testimony. Appreciate that. Do we have any neutral or opponent conferees in the committee meeting room or online? Seeing none, then we will close the hearing on House Bill 2517. Committee, we will now look at possible final action on a bill that we heard Monday, which was House Bill 2608, removing provisions authorizing criminal restitution to be enforced as a civil judgment and authorizing judicial districts to contract for collection services for criminal restitution. And with that, we will have a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson, Revisor's Office, as you said. This was the bill requested in the House by Allie Devine on behalf of Butler Law. A representative from Butler Law was the proponent that you heard from. It passed out of House Judiciary and then the House 117-4. This essentially takes certain civil restitution enforcement statutes that were declared unconstitutional by the Kansas Supreme Court and repeals those and replaces that process with a wage garnishment and other collection enforcement system that is not under those old statutes. It places them more in the criminal code and makes clear that you can authorize the agents that collect for the court pursuant to their contracts can also collect restitution. So it corrects or it replaces a system that was deemed unconstitutional with a system that they think would withstand constitutional muster under the case that they discussed.
Thank you. Committee, questions for the reviser? Yes, Senator Wilborn, question for the reviser?
Excuse me, Madam Chair, I must pull the trigger. I was going to make a comment later.
Okay. Before we get to that, questions for the reviser? Seeing none, then Senator Wilborn, did you have a comment or discussion?
Thank you, Madam Chair. I was in contact with some representatives from collection agencies, agreeing that the position of Butler and Associates is proper. It brings the bill back to where it was prior to the Supreme Court decision, and that maybe have been some misunderstanding as it relates to the opponent, but I would sure support the bill as written. Thank you.
Thank you, committee. Any other discussion? Senator Baumgardner.
Thank you, Madam Chair. I've received lots of comments and information since we had that hearing. My question, and I don't know if there's someone that really can answer this, but by bringing it back to the status quo, so if they go to the bank account, so if the ruling is that once the money goes into the account, those are no longer earnings, though the earnings are simply the wages before they're paid to the debtor. And so the money, once it's transferred into the account, so I guess Senator Wilborn, when you talked with others or the chair, where is the protection of no more than 25% of income earnings will be taken if there's not been garnishment already on the paycheck? So where is the limitation of the 25%? Because it does say our legislature has not enacted a restriction on garnishment on deposited wages. So can someone clarify that for us?
Thank you. That might be a question better for our reviser, that where is the 25% that has been enacted by the legislature? Where is that protection found in law?
Madam Chair, Jason Thompson, Revisor's Office. So you're only talking about the section that's on page
15, I think.
15, right. So at the bottom of page 15, so let's start from the first part, the definition of earnings that starts in line 23 on page 15. So earnings under current law means compensation paid or payable for personal services, etc. And that's where the disagreement is. What does paid or payable mean, and does that have significance with that change? The restriction is in subsection B, which is line 35. So it says, subject to the provisions of subsection E, only the aggregate disposable earnings of an individual may be subjected to wage garnishment. And so that disposable earnings phrase is up above, and it leans on the word defined earnings, right? So those all go together. And then the maximum part is the next sentence. The maximum part of such earnings, which may be subjected to wage garnishment for any work week or multiple thereof, may not exceed the lesser of 1, 25% of the individual's aggregate disposable earnings for that work week or multiple thereof, 2, a calculation based on 30 times the federal minimum hourly wage, or 3, the amount of the plaintiff's claim as found in the order of garnishment. So there's 3 different standards there, or 3 different numbers that you could have, and you have to choose the lesser of them. It cannot exceed the maximum allowed by the lesser of one of those 3 numbers. That's where I think the 25% comes in, if I'm not mistaken.
Thank you. Does that answer the question?
No, Madam Chair, because what we're talking about, I believe, if I'm reading that correctly, where we're talking about the restriction of wage garnishment, when you look at the definition of wage garnishment, that is removed prior to the electronic deposit. So if a debt is owed, the collectors contact the employer. They fill out the paperwork for the garnishment. The garnishment occurs and is subtracted from what would be deposited then into the employee's account. What we heard in testimony from the opponent was the ability for the collection agency to get into the bank account and take additional funds, if not all funds, out. Because once it's deposited, it's no longer wages. Once those funds are deposited by the employer through the electronic process, they're no longer wages. So what I'm looking for is where in the bill does it have that protection if the garnishment process wasn't completed, or if in fact they're wanting to speed up the collection, so to speak, that they can't go in there and exceed the 25%. That's my question. Thank you, Madam Chair.
I think the other part of the issue is that without the bill as drafted at line 23 on page 15, no criminal restitution can be collected and no garnishments for civil orders can be garnished either. So that without the bill as drafted, both victims of crime who have been ordered to be paid restitution and others cannot collect on court-ordered either restitution or civil judgments, was my understanding of why the need was for the change in line 23, page 15, because of the Supreme Court decision that came out in November. That was changing long-standing use of the statute to collect criminal restitution in particular, and this would also impact the ability, again, to enforce a civil court's order that money damages be paid. So my understanding is that without the bill as introduced, we would not have the ability, we being the rule of law, quite frankly, if we have civil or criminal orders of money to be paid, they could not be collected as has been the practice. If I have stated that correctly, I did not have a hand in writing the bill. So we heard from proponents and opponent, and I think we've had other conversations since Monday, if committee members have, with proponents or opponents. So, yes, other comments or questions? Senator Wilborn.
Thank you. And as usual, the good Senator Baumgartner always asks very good questions and deep thinker on this matter. As a practical matter, doesn't the debtor end up just switching bank accounts to shift away from any overlap on that limit?
Thank you, Senator Wilborn. I don't recall the testimony, but if that was perhaps in testimony, then in law, we do have on page 16 of the bill that is current law, lines 3 through 6, no one creditor may issue more than one garnishment against the earnings of the same judgment debtor during any one 30-day period. You can file a correction if needed for the garnishment, but so I think that's what you're talking about, Senator, or once you're a one-time attachment of funds in a bank account has been made, oftentimes, if I don't recall the testimony about what happens, but we can go back and review the testimony, or you have had the opportunity to do that. So yes, other questions or comments? Senator Gossage.
In listening to Senator Baumgartner's question, and again, I would just like clarification as to the difference between garnishment and restitution. Garnishment, right, is when it's taken out before it's paid to the individual. It's withheld by the employer, correct? And paid to whatever entity requested the garnishment.
Thank you, Senator. Wage garnishment can be different than criminal restitution, but I don't want to misspeak in that area, so I will ask the revisor. That can wage garnishment be used to fulfill a civil order of judgment as well as a criminal court proceeding order of restitution?
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So you're talking about restitution is the judgment, and civil judgments are also judgments. And then a means of enforcing the judgment would be the process of wage garnishment. And one of the pieces of this bill is to make clear that an order of restitution can be enforced via wage garnishment, as well as other means of collection, such as using the judicial administration's collecting agencies to collect in other ways, not just from wages. So it's one is an order or judgment, and the other is a means of collection. Hopefully that helps.
Thank you. Does that answer the question, Senator?
Kind of. So again, I'm just going to talk an example. So let's say that I committed a crime and then I owe restitution to someone, and I was paid, it went into my bank account, X amount of dollars. It wasn't garnished or kept by the employer. So then we're saying if that is paid into that account, then, and we're striking paid or, just forgive me, I just don't quite understand the difference between paid or payable. So if it's once it's in my account, the way I understood it was that means it's untouchable. So they couldn't get the restitution, if I'm understanding what you stated earlier, Madam Chair.
Without the bill as introduced, my understanding is that those funds would be not being able to be attached to pay for an order of restitution or a civil order for judgment, if I have that correct. Without the bill as introduced, monies in a bank account from whatever source, whether they're wages or some other source, once they're deposited, actually, I take that back, because we're talking about earnings and whether the earnings are paid or payable. Without the bill as introduced, those earnings, once they're in the bank account, would not be subject to being attached or otherwise garnished to be used to pay for criminal restitution or for civil damages, or quite frankly, for court fees or fines as well. Yes, Senator Baumgartner.
Thank you, Madam Chair. Sorry to take us down this winding path. It is very complicated. The garnishment occurs prior to being paid. So what we're really now talking about is earnings. There's a difference between earnings that would be paid, that could be garnished, and funds that you already have in your account, in an account. And I guess, not being a criminal, but thinking about the different bank accounts that we have, there's funds that go into our bank account from a variety of different things, not just earnings, not just a paycheck. So I think that we do have that resolved. At least now in my mind, it is resolved. Still a little trepidation that bank accounts aren't going to get wiped out. This may be something that we revisit again next year. It was troubling that we didn't have opponent testimony over in the House. We did in the Senate. So though I had originally asked for an amendment, I will not be offering that.
Thank you. Committee, further discussion, or do we have a motion? Yes, Senator Thompson.
Yeah, just so I'm clear, to follow up on Senator Baumgartner's thoughts. So in other words, the pay or paid, whatever monies, basically has to be intercepted on the way to that bank account. Is that how you read it? I mean, because if somebody's paid in cash for a job they do, say they're working on a farm or something like that, they would have to go out to the farmer and say, hey, this guy owes me blah, 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 X amount of dollars. So you would have to, it is very complicated.
Without the bill as introduced, that scenario is correct that you were just talking about.
Okay.
Without the bill as introduced,
Gotcha.
that would be the situation.
I think I understand.
Okay,
Thanks.
committee, yes. Senator Corson.
Thank you, Madam Chair. I think everything has been correctly explained. So my question is still more, I guess my concern that I raised for consideration is that I still don't believe there's any protection from for the 75% of a person's wages, unless I've misunderstood. I don't think that protection would apply to a bank account. So Kansas law protects 75% of your wages from garnishment. But once that money is in the bank account, they could wait till that money hits your bank account and attach the full amount of that bank account, taking 100% of what's ever in there, whether that's wages, whether that's savings, whether that was your holiday money that you a present that you put in, whatever. So I don't see any protection, again, for anything that's in the account, similarly to how we protect 75% of wages from garnishment.
Committee, other comments or questions or discussion? Seeing none, then do we have a motion on the bill? Yes, Senator Gossage.
I move we pass Senate Bill 2608 favorably for passage.
Thank
Out
you.
of
Committee,
committee.
is there a second? Senator Bowers with the second. Thank you. Committee, you all have heard the motion. All those in favor signify by saying aye. Aye. All those opposed, no. The motion carries. Committee, we will stand at ease for just a moment. Thank you. Committee, thank you for your continued attention. We will now turn to possible final action on bills that we heard yesterday. And with that, then we will ask for a bill brief from the reviser on House Bill 2607, clarifying the time limitations for habeas corpus claims. Mr. Reviser, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. So this is House Bill 2607. You did hear yesterday. This was requested by Representative Owens. It went through the House Committee on Corrections and Juvenile Justice, passed the House 120-0. The main change in this bill is to make clear that the time limitation for your subsequent habeas action challenging a prior habeas action, such as lack of adequate counsel on the previous habeas action. So your subsequent motion to challenge that prior one under this statute would be limited to 1 year from the date of the opinion of the last appellate court or the denial of certiorari, et cetera. So it would provide the same limitation that applies to other actions under this section. And I would note that the House Committee amended the bill, and you heard some testimony on this, to add sort of a safe harbor, if you will, or a gap provision so that anyone affected by the change in the statute of limitations for this action in the next year would be covered by the new subsection G. It does not bar an action brought within 1 year of the effective date of the act, which would be publication in the Kansas Register. So there'd be a brief period where this new law would not apply, so that all the other cases that might fall under that old statute of limitations could be dealt with, and then the new statute of limitations of 1 year would apply.
Thank you. Committee, questions for the reviser? House Bill 2607. Go ahead, Senator Pyle.
What was the House vote, please?
Yes, the House vote. Mr. Thompson? 120-0. Committee, questions for the reviser? Seeing none. Just a moment. Committee, any discussion on House Bill 2607? Seeing none, do we have a motion? Senator Wilborn?
Madam Chair, may I ask, was there any amendments on that I requested?
Oh, I'm sorry. Committee, any amendments on House Bill 2607? Not seeing any then.
Thank you.
Senator Baumgardner?
Thank you, Madam Chair. I move we pass out House Bill 2607. And I guess I will pause since it was unanimous on the House. Do we feel this is non-controversial enough to be on the consent agenda? Because if we do, then I would make that motion.
Committee, is this something we want to bring to the body as a whole to be debated on the floor or put on the consent calendar? So any discussion on that before we have the motion, I suppose. So seeing none then, yes, Senator Thompson.
Yeah, so I would second a motion if the chair feels like it is of a non-controversial nature.
I'm thinking with the 3 days it has to be on the calendar, is that enough days to get it where we need to be? I think it is. Mr. Thompson, with that? Right, we're on the floor next week, Monday, Tuesday, Wednesday. So that should be adequate time. So yeah, go ahead, Senator Baumgardner.
Thank you, Madam Chair. I do move that we pass out House Bill 2607 and have it put on the consent calendar. Favorable for passage.
Thank you. Senator Gossage with the second. Thank you. Committee, you've heard the motion. All those in favor signify by saying aye. All those opposed, no. The motion carries. We will now turn to possible final action on House Bill 2574, establishing a time limitation for awarding compensation for mental health counseling and increasing certain compensation award amounts by the Crime Victims Compensation Board. And with that, a bill brief from the revisor, Mr. Thompson.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. So this is the bill you heard yesterday about the Crime Victims Compensation Board, requested in the House by the Attorney General's Office on behalf of the board. It did pass the House 121-0. And there are really just a couple of different items in this. The simple one is a change in the amount of allowance expense to increase one for funeral expenses from $5,000 to $7,500, and one to increase crime scene cleanup from $1,000 to $2,500. So that's one piece of the bill. The second piece of the bill is to put back in some provisions that were in the law prior to its amendment last year. You made a number of changes. The legislature made a number of changes to this statute, and the ability to make claims sort of after the time limitations have run for certain individuals. In the process of doing that, you removed a provision that allows certain victims of sexually violent crime to file claims up to 10 years from the date of the crime, or a number of years after testing of a sexual assault kit is done, or they're asked to testify in a sexually violent predator case against one of an offender who victimized them. So those provisions that were removed last year are put in again. So essentially restoring some prior law. And then there's another statute of limitations issue in here, and I'm trying to find my note on it. The big one is restoring the one from last year. So maybe I'll just stop there and then see if you have any questions about the other parts.
Committee, questions for the revisor? Seeing none then, are there any amendments? Seeing none, any discussion on the bill? Or any motions on the bill? Senator Gossage.
In reviewing this bill, Madam Chair, since it's primarily funded through fines, fees, and penalties through the criminal justice system, and be able to help victims, I move that we pass Senate Bill 2574 favorably for passage out of this committee.
Thank you for the motion. Senator Haley with the second, or a question?
With the question following the same thread in the previous measure.
Thank you, Senator Haley. The vote was 121-0 in the House. Is this something you want
I would
to?
gladly amend my motion to be on the consent calendar, Madam Chair.
Thank you. And a second from Senator Baumgartner. Thank you. Mr. Revisor, do you have that motion correctly, or do we need to restate it? Great. Then with the motion from Senator Gossage to move House Bill 2574 out of committee favorably for passage and put onto the consent calendar, and the second from Senator Baumgartner. You all have heard the motion. All those in favor signify by saying aye. All those opposed, no. The motion carries. We will now look at possible final action on House Bill 2537, another bill that we heard yesterday, requiring the Insurance Department to hold a hearing in cases involving an order under the Kansas Administrative Procedure Act. With that, a bill brief from the revisor, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. As you mentioned, this is an act concerning an insurance statute and its relation to the Kansas Administrative Procedure Act. It was requested by Mike O'Neill of O'Neill Consulting. He was the main proponent you heard from yesterday. It went through House Judiciary. It did pass the House 121-0. The statute that's amended here currently requires or authorizes the Commissioner of Insurance to hold hearings on any matter relating to the business of insurance. And the addition is a new subsection that says any person that's subject to an order, as that term is used under the Administrative Procedure Act, that's going to be issued by the Commissioner or has been issued by the Commissioner, can request a hearing on that order. And if that request is made, the Commissioner shall conduct a hearing in accordance with the Administrative Procedures Act. So there's some dispute over whether that's required under current law because it does not specifically say a CAPA hearing is authorized. And generally speaking, you have to say it's authorized if it's to be done. And this would resolve that and make clear that a hearing is in order if it's requested. And that would be the rule going forward.
Committee, any questions for the revisor? Seeing none, then yes, Senator Thompson. Let me ask for amendments first. Any amendments? Or thank you, Senator Thompson. Then.
Thank you, Madam Chair. I move that we pass House Bill 2537 out favorably for passage, and because it's of a non-controversial nature, put it on the consent calendar.
Committee, second from Senator Gossage. Thank you. Committee, you have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, thank you for your attention today and your work here in committee today. Thank you for our proponent conferee and for those following along in the committee meeting room and online. And with that, then, we are adjourned.